So you got a client you can't handle. Client control is critical. You got to get out. You want to withdraw, and it's not an easy thing to do. The court won't let you withdraw from representation without some good reason. Well, we're going to pivot to Wisconsin. There's a sentencing hearing. Normally, any withdrawal is like early in the case, but this is a sentencing hearing for convicted killer Jessy Kurczewski. Turned into a little bit more than that. Turned into a motions hearing, really, for both of her attorneys saying, I want out. I got to get out of this case. Kurczewski is looking at a sentence of life in prison after the jury found her guilty of killing family friend Lynn Hernan with eye drops. Yeah, you remember the case. She was also found guilty of stealing from her. This attempt to withdraw follows the surfacing of this bizarre letter, allegedly written by Kurczewski. In this letter, it shows a plan to create a fraudulent recording appearing to be from the victim, Lynn Hernan. Kurczewski denies that she had anything to do with the letter, and nonetheless, it was turned over to the judge by the prosecutors. The defense motions for withdrawal were basically granted because it's the client turning on the attorneys. Okay, so her sentencing is still undone officially. It's on the calendar, but it's on hiatus for now as she awaits appointment of new attorneys, probably public defender at this point. It's just unusual to have new attorneys brought in only at sentencing, especially when it's a mandatory sentence. Anyway, that hearing is coming up on January 12th. Put that on your calendar. But for now, let's take a look at one of Kurczewski's defense attorneys and this motion for withdrawal.
Well, I think it's an actual conflict because I've got the potential of being an actual witness in the matter that has been submitted, because I know what the facts are of certain things, and I'm an actual witness. Some of the documents that were submitted are handwritten documents from trial. They're on the back side of handwritten documents from trial. I'm an actual witness to many things that are discussed either in the trial with the handwritten notes and questions that were asked and so on. So I don't know how I can, when there's a possible allegation of professional misconduct, because that would certainly be professional misconduct if I somehow took an envelope from Ms. Kurczewski and knowingly delivered it to somebody, knowing that there was a request that that person commit a violation of the law. That would be illegal and a professional misconduct. So that's why I'm asking. I believe withdrawal is mandatory.
I tell you, if you're the judge here, this is Judge Jennifer Duro, you might be thinking, why do I keep getting these cases? You might recognize her because she had the Darrell Brooks case, the defendant who represented himself in the driving of the car through the streets of Waukesha and running down parade members. That was something. So now she has this weird wrinkle in a relatively straightforward case. Catherine Lizardo still here, Bob Mata here. And, Bob, let me ask, you ever had to withdraw from a case?
Oh, yeah. Many times.
So give me, I mean, without breaking confidences, and it had to be public at some point, give me an example of why you had to get out.
A lot of times it's a breakdown in the attorney-client relationship. And it can be as much as, if I've got a strategy and my client doesn't agree with it, and we just cannot come to a meeting in the minds, and me realizing that strategically, that's my purview in terms of moving forward with a trial. But if my client's just adamant, like I hate your strategy and I'm not willing to go forward with it, at that point, it's not in either of our best interests, but in particular my clients, that we move forward with the relationship because there's a conflict there. So, I mean, it's typically something like that. A lot of times, I mean, it can be personalities clashing. I mean, there is no situation where, and it becomes a much more difficult challenge in cases where PDs or public defenders are appointed. These defendants don't really get the choice to say, okay, well, I don't like this guy or this gal, I want a new lawyer. Sometimes they're stuck with that lawyer. So as private counsel, if I've got a situation where it's arisen that there's just been a irreparable breakdown in the attorney-client relationship, then typically in that situation, I'll ask the judge to withdraw. And this situation's different. Like in this situation, she's throwing her attorney in the bus.
She's bagging on her own attorneys after the fact, almost as if to say, see, they did such a horrible job. Here's what really happened.
Well, it's even more than that, Michael. She's accusing the lawyer of cooking up this scheme. Like this isn't just her saying my lawyer did a terrible job. This is her saying that her lawyer cooked up this entire plan about it's pretty shocking. I can see why her attorney wanted to get out of it.
Yeah, and I want to hear though from the prosecution. And once we do, then Catherine, I'm going to have you weigh in. Here's how the prosecution handled this.
Hey, John, I'll just give a full recitation of how the state came to be in possession of these documents. On Monday, November 27th, Detective Plennis emailed the state's 3 prosecutors here and notified us of this document that was dropped off at the Sheriff's Department approximately 3:00 a.m. on that Sunday, November 26th. It was dropped off by the person whose name was on the receiving part of the folder, who we've redacted. It is a woman who Detective Plennis has spoken to and has learned that that person served at least a brief amount of time in the Waukesha County Jail with Ms. Kurczewski. We believe that individual was present for at least one day, if not more than one day, of the trial here, who had visits at the jail with Ms. Kurczewski by video, not in-person contacts, and had phone contacts with Ms. Kurczewski through Ms. Kurczewski's jail phone calls. So that individual basically was a person who was trying to support Ms. Kurczewski insofar as she knew what it was to be a criminal defendant and know what it was to either not have a great deal of support or need support, and wanted to support Ms. Kurczewski while the trial was going on. She came home on the 25th of November, that Saturday, and was informed that this package had been dropped off with her. She has apparently a service through the mail where she was able to determine it was not delivered by the Postal Service, but somebody dropped it off in the envelope that Your Honor has seen. We took note, obviously, with that story that the envelope, though it does have 2 stamps on it, not counting the Waukesha County Jail stamp, there are no Postal Service markings over those stamps, as you would typically see if it went through the post office. She began reading through the documents, became very concerned, was not sure what to do with them. She contacted her attorney from her previous criminal cases, who advised her to turn them into the Sheriff's Department.
For the prosecution, not really putting up a fight here, really just establishing how they got this 35-page letter. And if you get a chance and you got really nothing to do, you should read it. Handwritten. It's pretty incredible. Catherine Lizardo, I can't imagine you ever not getting along with your clients. I mean, you're mean and, you're spiteful and, never very cheerful. But have you had to withdraw? And if so, how did that go?
It does happen, and I have let go of some clients when they're the ones where we're having basically issues with our communication, like you were saying, because people have different personalities and different strategies. They have their different opinion on how they should be defended in a case or how a case should be pursued. So lawyers are human as well. So we have differing in opinions with our clients. And when that happened, that is a basis to withdraw as counsel. And here, as Bob mentioned, this is exactly, an issue that they have to withdraw. That we heard from the defense that they might be a witness because their client is throwing them under the bus. When the client throws you under the bus, I trust has been broken, and it's irreparable in terms of trying to communicate and zealously advocate for that client. Now, the wrinkle is this is the sentencing, not the start of the trial. So whoever's going to be the new attorney has to try to understand what's going on with the case immediately, and it might delay the sentencing hearing some more.
Yeah, and this is, again, it's a mandatory sentence, so we're just kind of playing out the string as to what the official result's going to be. But I would love to hear what the defendant has to say before the judge makes a decision. Maybe we'll take a quick break. When we come back, we'll hear from the defendant and the judge.